70% of Americans die without any plan for their estate. And COVID-19 has increased our awareness of how important it is to have an estate plan in place. Estate planning may seem like a low priority, but don't believe the misconception. Estate planning is not only for the elderly or the wealthy. Planning for the unexpected is best done today, especially if you have a family. Today's episode, we're going to go over some estate planning, the differences between a will and a trust. So let's jump on in. Three basic options to choose from when planning your estate. First option is no will, right? 70% of Americans leave nothing behind. They have nothing in place. Second option is last will and testament. This is what most people have, and there are three types. There's a holographic will, which is a handwritten will. There's a witness will, which is usually a lawyer prepared document. And the third type is an outdated will. It's just outdated. People have to update the information on it. What is probate? Probate is the court administration of your estate at your death. Which of the above three plans would likely be subject to probate? A person having no will, you're subject to probate. If you have a last will and testament in place, guess what? You're subject to probate. What estate size triggers probate in your area? Depending on what state you live in, the trigger for estate probate could be different. Here in Florida, the estate trigger is $75,000. So if you have an estate value of $75,000 or more, it will trigger probate. Why avoid probate? The main reason to avoid probate is because your total estate value will be taxed. They're going to tax you just to administer your assets or your estate to your loved ones or your friends or to the charities that of your choice. If your total estate value is $200,000, the government is going to tax you 8% and charge you $16,000 just to administer your estate. If your estate value is $500,000, the government is going to tax you 7%, which is $35,000 just to administer your estate. If your estate value is $1 million or more, you will be taxed at 6%, which is about $60,000 you will be taxed just to administer your estate. Is that a good enough reason to want to avoid probate? The average time to complete the whole probate process takes anywhere from 9 months to 2 years. Your estate will be frozen during the process and you have no control over it. And also, your will becomes public after your death. I don't know about you, I would like some privacy for me and my family, right? Don't want that type of information public. Revocable living trust versus wills and probate. Having a living trust in place, your trust avoids probate. Trusts eliminate lengthy delays. The 9 months to 2.5 years that the probate process has to go through, you eliminate that. Trusts also preserve your privacy, right? Nobody has to know your information. Your death will not be public. And also, trusts avoid court-appointed guardianship for your minors. I don't know about you, but I just don't want anybody to take care of my children in the event I'm not here. And I think a lot of mothers and fathers feel the same. All right, we want some type of privacy. Creating a living trust. Now let's jump into how to actually set up a living trust, what goes into it. First thing you want to do when you start your living trust is name yourself as the trustee. You and your spouse are the trustee of the trust. Name a successor trustee to represent you after your death. Name a healthcare agent to take care of you in case you are incapable. Name a guardian to raise your minor children that are left behind. Name the persons or charities you want to receive your estate. And you also want to retitle the assets in the name of the living trust with you and your spouse as the trustee. Funding the trust. What does it mean to fund the trust? Well, you can do that in a few different ways. First thing you can do to fund your trust is quitclaim your deeds and all your real estate to your trust. Your savings and investment accounts, your bank bonds, mutual funds, you can have your living trust as the beneficiary. Any other titleable assets like cars, boats, etc., you can also place into the living trust. You also might want to consider naming your trust as the secondary or contingent beneficiary to your IRAs and your 401k accounts. And you also want to name the living trust as second beneficiary to your life insurance policies. You want to keep your spouse as the second or the primary beneficiary and the living trust as the secondary beneficiary. If you fail to plan, then you indeed plan to fail. Think about your family. Think about your loved ones. Think about that staggering 70% of Americans who die without having any plan left over for their loved ones or their family. Do something now. Do something today. I hope you guys liked this episode. I hope you found some valuable information. Please like, share, leave a comment below. If you have any questions, please email me at theplentureshow@gmail.com, and I'll see you guys on the next episode.